Hello leaders, I'm Vanessa G. Nelson. Welcome to my 8th Nelson HR Report. I plan to come on every month to keep you informed of HR hot topics. So let's get started by talking about the EEO-1 pay data reporting. Now, what is the EEO-1 report? Well, first of all, EEO stands for Equal Employment Opportunity, and EEOC stands for Equal Employment Opportunity Commission. And the EEO-1 report is a federally mandated survey that collects workforce data from employers, which includes categories such as race, sex, ethnicity, and job categories. And the EEOC uses the information to enforce the federally protected employment discrimination laws and to enforce discriminatory or to prevent discriminatory pay practices. So also they analyze patterns regarding the number of women and minorities that companies employ to support civil rights enforcement. Okay, so under the law, employers with 100 or more employees or federal contractors with 50 or more employees and at least $50,000 in contract, they have to file an EEO report form by May 31st of 2019. So that's right around the corner. And you're required to file this every year, and typically it's going to be in March, but this year it has been extended to May 31st of this year because it's delayed because of the federal government shutdown. Now there are two components to the law. There's two components to the report. So the first component is what is due on May 31st. And the first component asks for the number of employees who work for the business by job category, race, ethnicity, and sex. Now component 2, we don't really need to be concerned about right now because it is in dispute. A judge had ordered a hearing for component 2, which was to take place yesterday. So therefore, right now you just want to concern yourself with component 1 and get that report in by May 31st. And you continue to watch the videos and we'll keep you informed of what follows with component 2. And just so you know, component 2 data includes hours worked and pay information for employees from their W-2 forms, and that's by race, ethnicity, sex, and job category as well. So we'll keep you informed of that. Now, if you feel that preparing for this EEO survey and filing your report is going to cause undue hardship, you are allowed to send in a written request for an exemption, or you also are allowed a one-time 30-day extension to turn it in. Now, if you have any further questions about the EEO-1 pay data reporting, then you want to go to the website, and there's a lot of information, frequently asked questions, and I'm going to have the link to the website right here in our video. Okay, our next topic, leaders, is the Family Medical and Leave Act, FMLA, and the Department of Labor, DOL's opinion letter. Now, over the years, I've had several clients who have inquired of me about, hey, I have an employee that is going on sick leave and she doesn't want to use FMLA yet. She wants to use her benefit time, and then maybe after that she'll go on FMLA. I've also had employers inquiring me about, hey, I have an employee who's really a good employee. They're getting close to exhausting their FMLA leave time, which we all know employees are entitled to 12 weeks of protected leave under FMLA, or 26 weeks for military or caregiver leave. So they'll say, well, we want to extend that leave for them because they're a good employee and we want to extend their FMLA time. So can we do that? So basically, the Department of Labor, the DOL, just issued an opinion on that. I was glad to see that. And on the one issue regarding an employee who wants to delay their FMLA time and say maybe use their paid time off or their benefit time for 2 weeks, 3 weeks before they take the FMLA time, the DOL's opinion actually says that they cannot delay the designation of FMLA qualifying leave, even if the employee prefers the delay. So when an employee goes off on sick leave, if it's FMLA qualifying, then they have to go on FMLA leave. Now, the other part of the letter regarding employers being more generous and giving more FMLA time, this is what the letter states, and I'm going to read it to you because I want to make sure I get it quoted exactly as written. It says, nothing in the FMLA prevents employers from adopting leave policies more generous than those required by the FMLA. However, an employer may not designate more than 12 weeks of leave or more than 26 weeks for military caregiver leave as FMLA. So in other words, you have the right to provide a more generous job protected leave, but it just can't be described as FMLA leave. Now, if you need more information on this issue, I'll have the website to the opinion letter right on this video. Also, employers, you may want to review your FMLA policies to make sure that you're in compliance with the DOL's position on these issues. Okay, the next topic, leaders, is the Murphy's Bill, which is aimed at a more stringent anti-harassment protections in the workplace. So, unfortunately, many workplaces are still riddled with harassment, and including sexual harassment. It's rampant, and it's become commonplace in a lot of companies and organizations. Now, I remember one day I went shopping, and as I stood in line waiting to pay for my purchases, there was a lady in line as well who was a well-dressed, very nice lady, and we began a casual conversation. And during the conversation, she expressed excitement that her boss had hired her daughter. She said, "Hey, I'm so excited. My daughter's going to be working. She's going to be bringing in her own money now." And then she kind of bent into me a little bit and said, "Well, I told her that, the boss, he's all right, but he might want to," I'm not going to say exactly what she said, but basically she said inappropriate touching. And he might do a little of that, but it's not a big deal. Just, deal with it and keep moving. And I was just kind of horrified for a second, and I didn't tell her, I was thinking, okay, she doesn't know she's talking to HR, which shouldn't matter. But I said to her, I said, well, there's things you can do about that. And she, oh, no, it's okay. It's harmless. So a lot of people have become immune to the harassment going on around them. And because it's running rampant, there was a bill introduced to Congress last week, and it's called Bringing an End to Harassment by Enhancing Accountability and Rejecting Discrimination in the Workplace, called Be Heard. And the bill is aimed at the following. It's aimed at investing in research about the impact of harassment, ensuring employees get information and training about what constitutes harassment, ending mandatory arbitrations for sexual harassment, ending pre-employment non-disclosure agreements, strengthening civil rights protections for all workers, extending statutes of limitations for harassment lawsuits, and this here is a big one. This one's a big one. Lifting the cap on damages when workers win sexual harassment lawsuits. So that could be huge for your organization. So we're going to keep track of this bill, and leaders will let you know what happens, what you need to be aware of. We'll keep you informed. But remember this, leaders. Please remember, it's very important to have a policy about sexual harassment and harassment. But it's really, really, really also very important that you provide regular, interactive harassment training for all employees to protect yourself. Now it's time for tip of the month. So leaders, our tip of the month this month is regarding references for former employees. Now, as you know, I'm the president of Expert Human Resources, but I'm also president of our HR group, and it's called Elite HR Professionals of Genesee County. So we meet bi-monthly, and we usually meet at 8:30 in the morning till 10:15. We have a big breakfast, and we have a great speaker, and you're welcome to attend. Message me if you're interested, and I'll get the information to you. So anyway, at our last meeting, we, as a group, we got into a discussion about references for former employees. Now, some of the members felt that, hey, we should never give information except the name of the job title, and the years of employment, dates of employment, I'm sorry. So we should only give those two things, and we should not talk any further about when someone needs a reference. Well, other members felt like you should be very open about the employee. So if they were fired or whatever happened, you should let the person requesting the reference know all this information. So we went back and forth with it. Now, personally, I typically recommend to my clients that they only give dates of employment and job title. However, I do have clients in some industries where there's a requirement, such as medical, such say a nurse that's abused a patient or a nurse that over-medicated someone. That may need to be reported, but that's usually in the policies. And also, I work with educational school systems where there may be a person who abused a child, or something in the past happened, or they may have been violent on the workplace toward a child. That would have to be reported, because that could get you in a situation of negligent hiring of a person. Now, so what do we do? So basically, I have 7 tips regarding providing references for former employees. And those tips are: number 1, know your state law about providing references. Some state laws allow an immunity for employers to protect them from litigation if they give references that are of good faith. Now, under the Michigan law, employers are immune from liability if we, as employers, in good faith, provide information from the employee's personnel file in response to a request from the current or former employee, unless the employee can prove the following. Now, if they can prove that you disclose false or misleading information, then that's a problem. So maybe you're mad at them, maybe you don't like them, or they did something that rubbed you the wrong way that day, and you just give misleading information. Or if you disclose information in a reckless manner or disregard of the truth, then, such as it's a rumor, you believe this rumor, so you're going to let this person know this is what happened, when it's, in essence, it's a rumor. Or you disclose something that was prohibited by law. Say you knew something about that person genetically. Maybe you knew that their father had a rare disease and that it could cause insurances to skyrocket, and you passed that along. That could be a problem if it was prohibited by law. Number 2, provide only information that is documented, such as dates of employment and title. Number 3, require a signed release from the former employee. Number 4, train your managers and supervisors to make sure they all know how to conduct references, and make sure that they're conducting references consistently. Number 5, send all reference requests to one area. And that would be like, you might send all the references to the HR area, so that person knows exactly how to do them. They're consistent with it. Or, and some companies have people fax in information with the employees sign off that approve you to give references. And number 6, provide only truthful information. That's about the 3rd time we talked about that. Provide only truthful information. Number 7, if you're not sure about your reference procedure and you're not sure if it's legal, then you want to run that by your HR or your legal team to make sure it is. So just make sure you're consistent and being truthful, and you should be good with references. And make sure you follow your state law. So that concludes my May Nelson HR report. Thank you so much for watching, and remember to love yourself, enjoy your family, and be safe. Also, get those HR audits done. You want to be efficient as possible, so get those done. So thank you very much. See you next month.
Learn how to protect your organization and improve your bottom line. Get your copy of Vanessa's book, 101 Costly HR Mistakes and How to Fix Them. Her book is packed full of real-life experiences and available to you now at Amazon.com or NelsonHRReport.com.